Hello, everybody. This is Isaiah from Habitat, Texas. I've had the pleasure of meeting some of y'all before, but for those that do not know me, I'm an intern here at Habitat, Texas for Miss Amy Ledbetter-Parham. And today I'm going to go ahead and introduce Mr. Zambi. Mr. Zambi is leading us on a transfer on death deed webinar right now. He is an undergraduate from UT and a law graduate from South Texas School of Law over in Houston. And right now he is going to lead us on a webinar on the transfer of death deed information and a new way to preserve family and estate property. So go ahead and take it away, Mr. Zambi.
Thank you, Isaiah, and thank you, Amy, for inviting me to speak to the folks here today. My name is Paul Zambi. I am an attorney over at Texas Legal Services Center, and while we do several things, the thing that I'm going to be talking to you about today, in which we have a grant to do for, is called the Transfer on Death Deed. And it is a new way to preserve family estate property. It is a will substitute which allows folks to transfer their land and their homes without the need of a will and without the need of probate. Right? If you could change the page. So currently in Texas there is a huge problem with something called clouded title. And how that happens is that folks pass away without a will, but yet they own house and a land or some sort of real property. And I'll go over the difference between real property and personal property in just a minute. But if they die without a will, and if they have, 3 kids, well, those 3 kids are going to have a right to a part of that property, and also possibly a spouse. If all the kids die without a will, well, if they have 2 or 3 kids each, then they also will have a interest in the property. And it gets down to the point where after several generations, a judge may have to decide, and it may be 12 people that own a portion of this, and it may be 1/8 here, 1/16 there, 1/4 here, depending on the closeness of those folks. So there are several reasons for folks just not doing a will. Obviously, there's the expense of one. It costs several $100s to get a will. A lot of folks are superstitious. Hey, if I do a will, I'm going to be gone the next day or something like that. So for whatever reason, they don't do it. And there's also a problem with getting a false sense of security. Let's say that somebody does have a will. If they pass away, many times their heirs will not even probate the will. And why is that? Well, let's say that they're living at home with the parents, or they move into the house afterwards. They can call up the county tax office and they can get the name changed into their name for those purposes, and they can keep paying the taxes. And county court, the county clerk doesn't matter. As long as they're getting the tax money, they're not going to foreclose on anything, and everything's going to be fine with them. But the person paying those taxes doesn't own the property. So paying the taxes is just wholly different from having your name on the deed. So enter the transfer on death deed. It is a fairly new law, September 1st of 2015. So those who have done, estate planning before that time would not have heard of this. They would have heard of something very similar called a ladybird deed, and that has been around for 30 years now. One of the problems that we feel with that is that there's no statute behind it. So title companies at any time can say, hey, we're going to get together and we're not going to accept these ladybird deeds, but also there's no way for somebody to look up to see what that does and what it doesn't do. So on the transfer on death deed, it is modeled after the ladybird deed, and it's about 90-95% of that. But it's a statute, so title companies can't just say we're not going to follow it. This is a Texas law. This isn't something that somebody just invented. And also, if you want to know what it can and can't do for a person doing estate planning, there's a statute to look up. So, you can look in the 3 or 4 pages of the statute, and it does this, it doesn't accomplish this. But we obviously prefer this because it is a known quantity, and that there's a statute behind it. About half the states do have one of these. They'll either call them transfer on death deeds or beneficiary deeds. The one that we're talking about today is for land located in Texas. So it doesn't matter if you reside in Texas, and let's say you've lived in Austin or San Antonio for 20 years. If your property is in Oklahoma or Arkansas, this is not for you. It's not where you reside. It's where the property is located. Conversely, if you do live outside of the state but you own property here, you can avail yourself of it. The deed has to be filed in the property in the county where the property is located. And again, choose one of your 254 counties in Texas, but it's got to be filed before somebody passes away in the county where the property is located. All right, next slide, please. So, I don't know if anybody on the line has ever had to help anybody go through probate, whether it be with a will or without a will. But I mean, it's a pain. Yeah, I've heard it described as a major inconvenience to a nightmare. It costs a lot. It takes a lot of time. There's a lot of actions that needs to be done. A lot of court approval and judge approval. The administrator or executor has to be approved. I mean, it's not a simple process. And ultimately the judge is going to have to decide who gets what, or they're going to have to follow what the will says. In order to give property, but really all a will does is that it tells a judge who you want to get your things. It doesn't do anything to transfer title. So if in the will it says, Johnny gets my home, well, Johnny just doesn't get the home. You have to go down and probate the will. So whereas the transfer on death deed, if you put in there that Johnny gets the home, he gets the home just like a life insurance policy or a bank account that's passed on. There is no need for probate. So that's a huge, thing. And again, the problem, especially if you die without a will, is let's say that a judge decides that the three people, have an interest in the property. And if those three people have different ideas about what to do with the property, then problems arise. One wants to keep it, one wants to sell it, one wants to rent it. They can't agree. It's not going to be sold unless they all agree, unless there's further, court action. And a lot of times one will get angry at the other. They'll say, I'm not going to pay my share of the taxes or the maintenance and upkeep. And so that burden shifts on to the other two. They're either unable or unwilling to do it. And we've actually seen houses get, foreclosed on because of this, because of lack of payment of taxes or mortgage or just whatever it is. So if you die without a will, it basically just adds stress and uncertainty to financial matters, and it hinders your ability to pass on wealth to your heirs. Okay, next slide, please. So the benefits of the TODD. Again, the biggest one and the reason that the law was written was to avoid probate. So again, there's no cost and time required for probate. The deed passes to the person upon death, and not just the right to it as a will does, but actual title to it. It avoids splintering of the estate. As far as the money savings, on the front end, a person is going to save hundreds of dollars by not having to pay an attorney to prepare a will. Their heirs are going to pay thousands of dollars by not having to probate the will. But the thing that people seem most excited about, at least my clients, are that if you transfer a property with a transfer on death deed, it actually shields the property from Medicaid estate recovery. And I have a slide next on that, but that's where the government, if they give you services, can come in and take your home after that. And that's a savings of, tens of thousands of dollars or more. So I think that everybody in Texas who owns property should do a transfer on death deed, even if they still need their will for other things. If they have a lot of other monies, personal property things that have to be disposed of, you may still need a will. But especially for my clients who are lower income, and you might call them house rich and cash poor, because obviously this is for folks who own homes, but they don't have a lot of other funds. A lot of those don't even need a will. And at the end of this, I'm going to go over the 3 things you can do just for anybody to avoid probate, unless they have a really, really complicated estate. But again, my clients, most of them do not need a will anymore if they have this transfer on death deed, because it's 95% of what they own that's tied up in their home. If you could change the slide, please. So I mentioned about that Medicaid estate recovery. So little bit of history. Before 1993, there was no recovery whatsoever. The federal government gave money to the states for Medicaid, nursing homes, in-home care, things like that. And in 1993, they decided that they had to recover some of that money. So they passed a law in 1993. Every state has to have a Medicaid estate recovery program. Every state gets to administer that differently, and that's huge. So Texas was actually one of about 3 states or 3 or 4 states that said, we're not going to do that. I mean, we still want to give them these nursing home care privileges or these in-home care privileges, but we don't want to take the homes away from our folks, so they didn't do it. So in 2005, the federal government just held their feet to the fire, and they made those states implement their recovery program, or else they would withhold or just not give them funds whatsoever. So if anybody is on Medicaid from before 2005, they're grandfathered in, and they can still get those services, and there is no penalty. But starting in 2005, for those who are eligible for and who begin nursing home care, it's great, and the folks who sign you up, for that thing, from formerly DADS, now HHSC, they're nice people. But one thing that they have to do is show them this Form 8001, and they ask them to sign it, which says that, hey, this is just an acknowledgement that if you get these services, and if you have anything substantial in your estate when you pass away, we get to claim it. And that's usually the home. I mean, they're not going to take tables and chairs and nickel and dime stuff that, they'd have to sell at a garage sale. They're looking for the low-hanging fruit, the homes and other things of that sort. So that was implemented in 2005, and that can and does happen. So the saddest thing we hear is of people needing these nursing home care or other services, and they're eligible for them, but they walk away from them because they say, my gosh, even though I need these, if you're going to threaten to take away the only thing I've ever worked for throughout my life and saved up for, even if my house is modest, a $50,000, $60,000, $70,000 home, I'm going to walk away from these services. I don't want you to take my home. So if anybody hears of that ever, there is an answer to that now. It's this transfer on death deed. A lot of folks do know about it, and so they go into those meetings with a little bit of knowledge, and that can be a dangerous thing. So in those examples where they say, hey, mom and dad are going to need nursing home care in a couple of years, but boy, they have this home here, we got to get it out of their name so Medicaid can't get it. So they gift it over to a son or daughter for $10, love and affection, and that is the absolute wrong thing to do for a couple reasons. The first is that when you're applying for Medicaid, they do a 5-year search on you. They can go back 5 years. It's very thorough, and they will look to see if you have transferred anything for below fair market value. And that's, giving a home away. That's usually the prime thing of that. And if they find that out, they will ding you for it. They will either deny you services outright, or they will, delay those services, or just whatever. So, a lot of people try and get cute and do that and save the property. It only hurts. The other aspect of that is that when you transfer a property like that, the person you're transferring it to is probably going to be paying higher taxes on that property on an annual basis. And this is a little estate tip. If somebody who owns the property is over 65 years old, and that's their only home, so they have it as their homestead, they should have 2 exemptions on that property. One is the homestead exemption, which everybody knows about. But the other one that a lot of people don't is an over 65 exemption. So whether it be you or you need to check your parents today to see if they have not only the homestead but the over 65 exemption. Okay? And that's everybody. You don't have to choose between those two. You get them both if you qualify for them both. So if they try and subvert Medicaid and they transfer that property to a child who's 45 years old and who already has a home, so they're using their homestead there, they don't get those two exemptions. So again, they're going to be paying higher taxes on a yearly basis on that property. But again, the worst part of it is that them just getting outright denied the services because Medicaid has done their 60-month look back, which is 5 years, and figured out that they've transferred something below fair market value. If you could change the screen, please. So, who qualifies for the transfer on death deed? Again, when I talk about us being able to do it for free, it's at a certain income level, and I'll go over those at the end. But the law is for everybody in Texas. It doesn't matter your age. It doesn't matter your income. You're allowed to use this for your real property. And real property includes your land, the homes on the land, mineral rights, timber interests, and even cemetery plots and things like that. It does not include personal property, which is things that are easily moved away, furniture, guns, clothing, jewelry, things of that sort. So the problem that we get those calls of those people who are eligible for our service, and they own a plot of land with a home on it, and they'd like to do this for both. But then we ask a few more questions, and we find out that the home that they live in is actually a mobile home or a manufactured home that was moved onto there. And generally, when those are purchased, those are personal property, and they will not convey with the transfer on death deed. So watch out for that. Now, obviously, that's not going to affect y'all. Y'all actually build the homes on there, and those would be real property. But, for our purposes, land is always 100% of the time considered real property. Sometimes the home is, sometimes it's not. Again, in y'all's situation, for what you do, those are considered real property. It is one TODD per property. So if you have two properties or another plot of land, you have to do a separate one for this. When you have a will, and if you still needed that, the language in a will says, upon my death, I give all my real property to so-and-so. And when you wrote the will 20 years ago, you may have owned a home. Now you may be on your fourth home and you don't own the others anymore, or maybe you own 2 homes or 3 homes or something like that. Well, in that case, all of your real property transfers to that person. If it's 1 home, 4 down the line, if it's 3 homes, whatever it is. But because the TODD requires a specific property description, if you sell that home, the TODD becomes, ineffective, invalid, and you would have to do another one for your next home. Or if you have 2 properties, you have to do 2 different ones because it needs a separate property description. A lot of folks who are elderly rely on powers of attorney that they give to their adult children. This specifically cannot be done with a power of attorney. Those are good for a lot of things. Opening up bank accounts, doing other things with real estate, they can be very helpful. The framers of this legislation were concerned about elder abuse and, an adult child taking the home away from their parent or something along those lines. So anyways, a transfer on death deed cannot be executed with a power of attorney. Somebody who does this must be competent. They must understand the nature and consequences of their actions. They need to be able to sign, all that stuff. A person who does this must be a person. And what I mean by that is, if you've already done a little estate planning or something along those lines, maybe they don't own the property anymore. They've transferred it to a trust. Or if it's a rental property, they formed a corporation. So then they don't own it. The trust does or the corporation does. So, we like this so much, the natural thing would be to say, oh, take it out of the trust or corporation and do one of these transfer on death deeds. Well, that may not always be necessary. I mean, a lot of trusts already transfer properties outside of the probate court, so it solves that problem. If you formed a corporation for tax purposes, maybe that's more important to you. So you don't necessarily have to to, get those out to do a transfer and debt deed. You wouldn't be able to do one, but if it's not in your name, again, if it's in a corporation's name or a trust, you would not be able to do this. We do get those calls, hey, Paul, I'd like to do one of these, but I don't own the property outright, so I have to wait, right? Absolutely not. I mean, if it's a $100,000 home and you paid off $70,000, but you still have a $30,000 mortgage, yes, of course you can do one of these. If you pass away, you pass on $70,000 worth of equity. You do pass on a $30,000 mortgage that still has to be accounted for and taken care of, but you're passing something of value. And it's the same thing where 2 or 3 people own a home. Maybe 3 brothers or sisters own it, or a mother and daughter, even a husband and wife. Hey, Paul, I don't own it all, so I can't do one of these. Yes, of course you can. You're transferring your 1/2 or 1/3 or whatever it is cleanly. Hopefully those other folks have taken care of their portion, but they may want to give it to somebody else than you're giving yours to. So, you can do a transfer and death deed whether you own a fraction of the property or whether you're not finished paying off the property. Next slide, please. On the other end, who qualifies to receive it? That's anybody. So on the front end, when I had said that it has to be a person who is the transferor, who the beneficiary can be anybody or anything. So it can be obviously a person or persons. There's room on the form for one or more. You don't just have to limit it to one or choose one. You can leave it to a trust or a corporation, or you can leave it to a charity or another organization or association. In our early days, we had one lady who was elderly. She had 4 kids, adult kids. They didn't get along for some reason. I don't know what happened, but she wasn't happy about it. She had this home, and she didn't want to leave it to any of them. So we actually wrote it up and set it up where she was leaving it to the Houston Humane Society, and that's a perfectly good thing to do on the other end. So you don't have to leave it to a person. You can leave it to another organization or association.
You say it must survive the passing of the grantor by 5 days.
Correct, and that's generally what a lot of wills have as well. So, the only time that would really come into effect is, let's say people are in an auto accident. One person dies immediately, the other one hangs on for 3 days in a coma and then passes away. It wouldn't pass then. But yes, generally, specifically, somebody has to live 5 days past the passing of the grantor. And by the way, this is a small enough group where if y'all do have questions in here, you can answer them in real time here. You don't have to wait until the end, all right? As I mentioned, you're allowed to give it to one child or multiple children. So that just depends on your family dynamic. So a lot of folks who have 4 kids, adult kids, say, Paul, can I put all 4? Absolutely, you can definitely do it. The problem there is that's when you find out whether you really get along with your brothers and sisters, because we've had those calls where, Paul, everybody got along until mom or dad died, and that's when the fighting started. And of course, when there's something to fight over, like the value of a home, that's when it happens. And again, if 3 kids get it or 4 kids get it, and one of them doesn't want to sell it, it's not going to get sold, and it's going to gum things up. So if your family dynamic is such that the kids are going to feel left out and be hurt that you didn't give it to them, you leave it to all 3 or 4, and hopefully they'll get along. Your family dynamic may be such that you leave it to one child out of your 4, knowing that you trust that child and that they're going to sell the property and, then split up the money and be a good caretaker of that. So, but again, the form, you're allowed to leave it to one person or multiple folks in there. Next slide, please. The form itself is fairly easy, and we do have free ones online. At the end, again, I'm going to tell you what our qualifications are. We would love, first crack at it. It's always best if an attorney fills one out. We do have the do-it-yourself form, so again, an individual can fill them out for themselves with hopefully some guidance. What you should not do is you should not fill out a form for somebody else. That can get into the practice of law. Imagine making a mistake on that and them trying to come back after you because you filled it out wrong and it didn't transfer the way they wanted. But again, an attorney can do it for somebody. You can do it yourself. You shouldn't do it for someone else. I have heard anecdotally around the state that attorneys are charging anywhere from $150 to $600 for this. So again, we'll get into that in just a bit. On the form, you need names and addresses of the grantor and grantees. It has to be notarized. It has to be filed with the local county clerk's office where the property is located. The biggest problem where folks can mess up is getting a good property description. There are good instructions on the forms that we have online. We obviously do it, for you, and we solve that problem. A good property description is not the property address, and it is not the property description that is found on your annual tax bill that you get in. Those are transferred or written by a clerk onto that program. They may only have half a line or a line. It can be inaccurate. It is usually incomplete because these descriptions can be 5 lines long or a page long, and that doesn't fit onto the tax roll. So you need to get the property description from a previously filed deed, not from the tax roll. And again, where we have our free forms are at www.texaslawhelp.org. So that's that last line there. Again, that's our website where you can find information on any sort of law you want, guardianship, divorce, bankruptcy. Again, some of them have forms, some of them don't. This is one that has a form. So in the search tab, you would type in transfer and death deed, and then this form would pop up. Again, that is for folks who are over income or just want to do it themselves. Obviously, if you have somebody in mind, please have them call us. If they're eligible, we'll help them. If they're not, we will direct them towards the free forms. Because we're a legal aid, we are not gotcha people. Somebody won't call up here and we'll say, oh, you're $5 over the limit. We can still do it for you. We'll just charge you $300 or $400. We don't do that. We're a legal aid. We're not allowed to accept money. If we did, we would lose our grant. So we can either help you or we refer you out to the free forms. Again, it does have to be filed before someone passes away. I know there was an instance before where it was a matter of a couple days, and that may be okay, especially if things happen on a weekend. But we have those calls where, Paul, I had a husband pass away. Can I do one of these? No, it needs to be filed before somebody passes away. The problem we see there is that if somebody's husband died a few years ago, I just say, look, you need to go and probate that will if they had one, at least get things straight. You can do a transfer on death deed from here on out, because a transfer on death deed doesn't correct anything in the past. It just does it going forward. So I tell them that, yeah, it's going to cost you some money to do it. And so my spirits are at least a little up because they have a will to fall back on. But then they say, okay, well, he died 5 years ago. I'll find it and I'll probate it. And then that's when my spirits sink again, because if you have a will, it needs to be probated within 4 years. So again, we have a lot of adult children in Texas not probating a will because of the cost, but being lulled into that false sense of security because they're paying the taxes, and they figure if I'm paying the taxes, I own it. And again, that's just not how it works. So, things have to be planned out. Next slide, please. A couple more differences between a TODD and a will. With a will, you just need your 2 signatures. It has to be notarized, and you're good to go. It doesn't have to be filed anywhere. If you stick it under your mattress and you pull it out 30 years later when it's needed, that's a perfectly good document. A TODD is different. You don't need witnesses. It does have to be notarized, and then it does have to be filed. If there are different bequeaths in a will versus a TODD, anything in the TODD as it relates to real property will trump the will. So let's say that you did a will and you named Johnny in there. You want him to get your property, and that was a couple years ago. Well, Johnny either has won the lottery and he doesn't need it, or maybe he's gotten on drugs or alcohol and you don't want him to have it because you're afraid that he'll sell it just for to support that habit. If you name Johnny 2 years ago in a will and Susie today in a transfer on death deed, Susie gets the property. And it doesn't matter if it's later in time. If you do a will 30 years ago and if you do one today, the one today rules. It supersedes the other one. Same with the TODD. If you do one today and if you do one 6 months from now, the provisions in the most recent one rule. But even if you do a will, whether it be before or whether you do a will after the transfer on death deed, that doesn't matter. When you're talking about the real property, whoever you name in the TODD, that trumps what is in the will. Now, having said that, if you do have a will that names someone and a TODD that names somebody else, you should try and sync those up just to avoid the inconsistency. You're just inviting a probate action there because someone's gonna, get the will and say, I wanna take under this, even though he'll ultimately, be ruled against. Money has still been spent and time is still spent. So, again, a lot of estate planning is just telling your kids what your intentions are. If you do need a will in addition to a transfer on death deed because you've got a lot of other non-real property stuff or just a complicated scenario, and let's say that you do have one kid who's a no-good Nick. You just don't want him to have everything. You don't want him to get anything, whether because he doesn't get along with you or he's on drugs, whatever. If you do have a will, you should name all of your children in the will. And on the first two, you can say, hey, I want them to get all my real property and my personal property. The third one, you should give them $10 or $5 or something. And the reason you do that is that if you just completely leave them out, they can come back later and say, oh, Mom and Dad wanted to give me everything. They just forgot to put me in the will. So when the judge reads it and says, nope, those get everything, you get your $10, off on your way with your $10, that's the safer thing to do. So you should name everybody in a will. All right, next slide. What is the effect of filing a TODD? When you file it, the effect is absolutely zero. The grantor, the person who filled it out, the transferor, retains all the ownership rights and responsibilities. So they can get a mortgage loan on the property. They can sell the property. Whoever they've named as beneficiary, they don't need to get their approval whatsoever because they haven't passed away. Zero interest has passed on to that other person. But by the same token, they have all the responsibilities. Just because it's filed and you've named a beneficiary, if there's taxes on the home or a mortgage remaining or insurance, whatever it is, that's your responsibility. Again, nothing is transferred. So, the beneficiary doesn't have any say in it whatsoever. By that token, the beneficiary doesn't get penalized. Let's say the beneficiary is trying to get on some sort of government assistance or something like that. Well, this house that has just been promised to them but hasn't been given to them does not count as an asset, in any of the income calculations, the eligibility calculations. The only time we could ever figure out that could hurt somebody is if somebody is on some services or they refuse the house just to avoid getting that. That can be considered a transfer without consideration. Why would anybody refuse that? It would be just for that purposes, or sometimes the house is upside down on its mortgage. For whatever reason, the mortgage is $100,000 and the house is only worth $90,000. Well, then you're not passing an asset, you're passing a liability. And there's actually a provision in here where you can actually disclaim the property. All right, next slide, please. When you receiving property through the TODD, as I talked about early on, the person who receives it literally just steps into the shoes of the grantor. So, if there's a mortgage due, they got to continue that mortgage. If there's taxes or back taxes, they got to continue that. I mean, we talked about that great aspect of the TODD that it protects it from Medicaid estate recovery, but that's the only thing it does. The drafters of the legislation specifically did not want the TODD to subvert other creditors. So creditors' claims can last up to 2 years when you use one of these. The creditor has to reaffirm that within that time. But, you don't just use this to get out of a personal judgment or something that's been filed against your property, or if there's a child support lien that was filed against your property, it doesn't protect against any of that. The only thing is the Medicaid estate recovery. So a person taking under this would then file in the same place that the original TODD was filed an affidavit of death and a certificate of death issued by the county. And that's what a title company looks for. You know, when someone's getting a loan or wants to sell a property, a title company doesn't call up people and say, hey, what's the deal with this property? They look to see what's in the permanent record. And that is what is on file with the county clerk's office. So when they see the transfer and death deed there, as well as the affidavit of death and certificate of death, those are the only, pieces of information they need to transfer title to that property when the need arises. We talked about the creditors may being able to come back, within 2 years to reassert their claims. Again, mortgages and taxes are the responsibility of the owner. We get the question a lot of times, hey, if somebody takes under it and there's a mortgage, do they have to reapply with a mortgage company? And again, while there's no hard and fast rule how it works with wills and how we think it'll work here, is that if you're a family member, they probably would not make you reapply and go through that process. But if you're a neighbor or a fishing buddy, they may very well. So again, you're allowed to leave it to anybody. If there's a mortgage, that's up to the title company about what they do.
Can I ask a quick question?
Sure,
Our
yes.
attorney said that with our liens in place, the habitat liens, we could choose to foreclose or allow this person to continue to make payments. We can exercise the repurchase right as well. So as a Habitat affiliate, what do we do in this case?
Well, and correct. So again, this is for just normal people on the street. Y'all, and I know that over the years you've kind of changed your thing. It used to be like maybe after 2 or 3 years they would get more rights, and then after 5 years more rights, and 10 years. Now I think you're under one straight thing where it's what you call it shared responsibility or shared benefit, where after 10 years then they can pretty much do what they want with it. If I'm wrong, correct me there. But yes, if somebody tries to sell the home, Habitat has first right of refusal, and they will buy it for the lower rate or whatever has been agreed on. And again, if somebody leaves it to somebody, I think Habitat would like it if it was left to a family member. There's a lot more leeway there, as long as that family member isn't like Scrooge McDuck and really, really rich. But if they try to leave it to another person outside the family, I think Habitat will make sure that that person is of low income or modest income. If they are of higher income, I believe that Habitat does have the first right of refusal to buy it or switch it over to somebody else. So again, I'm not exactly sure, all that Habitat does and all their rules, but I know that there are restrictions on that, but that after 10 years there's a lot fewer restrictions. So I know Amy or other folks would be better to clear that up. All right, next slide, please. Real quickly, separate property versus community property. Everybody's heard that phrase, hey, if we're married, every dollar I earn, 50 cents is his or hers. And that's true. That's for income during the marriage. It is property acquired during the marriage. So again, we get people lulled into a false sense of security, though, if they're a married couple and they buy a property, and one of them dies without any estate planning, well, that spouse, they just figure it goes over to the other spouse, correct? That may or may not be the case, and most of the time it depends on whether that person had a prior marriage or other kids or something like that. But again, you would still have to do something to transfer title, whether it be an affidavit of heirship or something like that. But again, folks are lulled into that false sense of security. We've had folks call us, my husband died 15 years ago. Of course it's mine. I've been paying the taxes, and nobody said anything. That may or may not be the case, depending. So on our form, We have, we usually do 2 TODDs for married couples, and we name each other as the primary beneficiary. So if one dies, it goes to the other. And then we hope that they agree on the alternate. So when the second spouse dies, you don't have to file a new TODD. It just then passes on to the alternates, which are usually the kids of the marriage. So that's generally how it works. With separate property, that is property that is gotten before the marriage, so you buy your home before the marriage, or it's gotten during the marriage by gift or inheritance. So if Uncle Wally dies and leaves you a home or a $30,000 CD, that's yours. And in those cases, we just do one transfer on death deed for the person who owns it, not one for the spouse. And the one who owns it, that spouse doesn't even have to leave it anything to the other spouse. They can leave it to a niece or neighbor or just whatever it is. So again, community property is treated a little bit differently from separate property. Next slide. And we're coming up near the end here. So it is a transfer on death deed. It sounds so permanent, and because it's filed on there, my gosh, this is permanent. But it is a revocable transfer on death deed. So if you file this and if you change your mind, you can do so. You can either do an outright cancellation of the form, and that's one of the statutory forms online. You can do a new one. So let's say that Johnny, either got on drugs or maybe won the lottery. You want to leave it to someone else. Once you do that new one, it makes the old one ineffective, and then the new one rules. If you get divorced, in that situation where you've named your spouse as the primary beneficiary and your kids as the alternate, well, if you get divorced, things probably didn't work out there. You probably don't want the spouse to get it. As long as you file that divorce within the county where the property is located and where the original TODD was filed, that spouse will not take under the transfer on death deed, and it'll skip straight down to the alternates instead of going to your divorced spouse. As I said before, you're allowed to sell the home, and if you do that, that's basically a cancellation because it makes the TODD ineffective. When you die, they're going to look at that TODD. You don't own that property anymore, so it's just an invalid document. You've heard of those stories where, a grandparent calls the family together. He's angry at them, and he tears up the will in front of them and says, I don't want anybody to take under this. That may be perfectly good for that grandparent to convey his intent that nobody is to take under the will. Not so with the transfer on death deed. If you get angry with them and if you tear up the transfer on death deed, it has no effect because it's been filed at the courthouse. So if you're going to negate it or cancel it somehow, you need to do that special, whether it be with a cancellation or a new one or just what. So we're at the end. I told you I was going to tell you how to avoid probate. So everybody here usually has 3 groups of things. They have their home, they have their cars, and they have their land. If you do the home with a transfer on death deed, you can avoid probate because it passes it outside of there. For your vehicle, there is a special form. If you're husband and wife, obviously it goes to the other one of them. You just have to sign the front of your title, and that's good. But let's say that you don't have a spouse, and the car is just in your name, and you wanted to leave it to your kids. Well, if that car is worth $5,000, whatever it is, somebody may have to go through probate to get that out. I think now they've had it where there's certain forms down at the DMV where you can, after the fact, kind of clear that up, do what's called an affidavit of heirship. But before you pass away, as far as estate planning, there is a form, and it's called the VTR 122, and it is a right of survivorship form. It's not our form. It's not on our website. It's on the Texas Department of Motor Vehicles website. It's the VTR 122, and if you fill it out and if you file it, when you pass away, not only the right to the car, but title to the car transfers. And again, title is what probate is needed for, and if you don't need to transfer title, you wouldn't have to go through probate on that. Bank accounts. Anybody who has stocks or mutual funds through Schwab, Fidelity, T. Rowe Price, whatever it is, I guarantee you on the form, one of the things they ask you is who do you want as your beneficiary, and those things will pass outside of the probate court. with savings and checkings account. Those things are available also. So with those things, you can hold those in 3 different ways. So if I open up a checking account or savings account and it's just in my name, well then I have total control over it during my life. I'm the one who makes the deposits and the withdrawals. Nobody else can do it. The problem is if I pass away and there's $3,000 in there and I want my kid to get it, he's going to have to pay $1,000, $1,500 to get title to that, and it's just a waste. So another way of doing it is if you trust a son or daughter, an adult child, and you make it a joint account, well then that person has the right to make the withdrawals and deposits as well. The problem there obviously is you've heard those stories where then the adult son or daughter can drain the account as well, and we've had a couple calls like that. If you want to hold it like that and you trust your son or daughter, that's fine. Make sure it is a joint account with right of survivorship. You have to have those magic words, right of survivorship. The other way of holding it is just like a transfer on debt deed for the homes. It's called a payable on death account. And what that is you open it up. It's in your name only. You are the only one who has the right to make the deposits and the withdrawals. But when you pass away, you have named a beneficiary, a payable on death. So that will pass it outside of the probate court. And again, that protects it from Medicaid estate recovery. Anything that passes outside of the probate is protected from Medicaid estate recovery. All right, last slide, please. So, to some, we're Texas Legal Services Center. We help folks all throughout Texas, all 254 counties. So do not let geography be a hindrance to you sending somebody over here. We do help those within 200% of the federal poverty guidelines. Generally, for an individual, they can earn up to $2,000 a month in Social Security. I think y'all might even have the people you help may have even some lesser guidelines than that, meaning they can only earn less. I don't know. I think in some cases it's more, in some cases it's less. But for when we can do it for free, an individual can earn $2,000, and if it's a couple, their Social Securities or whatever pensions can add up to about $2,700, and then we can help them for free. And again, if we can't, we will refer them to the website for our free forms. The only costs that they would have, whether they do it themselves or whether we help them, is about $50 each. And that's because each form has to be notarized. And again, you may have to pay someone $10 for that, or maybe their bank does it for free. First, you would check with the bank, because a lot of times they will do that for free. And then the other thing is filing fees. Again, it needs to be filed. Those filing fees are about $30 to $40 throughout the state. So again, those are the costs, less than $50. The last thing I'll say is that beware of scammers. Whether we do it for folks or whether somebody does it on their own, we have had calls and reports that about 2 weeks later, people have gotten a bill in the mail for $89 as it relates to it. And it ends up, it's a very official looking bill, and it's out of a P.O. box out of Austin. So a lot of people think it's us, but it's not. And what they'll do for that $89 is to get them a copy of what they just filed. So they're doing nothing substantive, not filling out anything, not preparing anything. They're just getting what costs about $2 or $3 to get down at the courthouse. So if you hear of anybody doing this and them getting that bill, just tell them to ignore it. We're afraid that if even 3 or 5% of the elderly population does it, $89 is a lot to them, and you're just enriching some scammer down there. And next page, well, really that's it. So my name and information are on here. If you turn the page, it has it on the last page there, as well as my website. If anybody here, I'll stay as long today as I can. If anybody has questions, or if anybody has any later on, they can call me or email me or contact me. I'll send them our pamphlets, our written information about different things. And thank you very much.
Thank you very much.
I would just like to thank everybody for participating in the webinar. If you have any questions whatsoever, feel free to contact us or call us or email us, and we would love to answer any questions you have. Thank you.
Paul, I was just tell you, this is Christian Houston. I've used the website. It's very, very user-friendly. I did a do-it-yourself divorce for my brother, and it was very, very helpful, user-friendly, all the forms, very good instructions, and was able to do it